Hello everyone and welcome back to your channel Lawpedia. So in this particular video, we'll be discussing the concept of will. So as you all are aware about, unfortunately, life comes to an end and one day you leave behind a bunch of things for your surviving family members that range from your priceless memories, wisdom and your own inside jokes. And apart from that, you also leave behind a very important quantifiable thing, that is your property. And this often becomes a ground for dispute and increase in the family litigation area. So in this particular context, we need to understand the concept of will. That means हम इस वीडियो में समझेंगे what is the concept of will all about. So let's get started with the video. So before moving forward, I wanted to discuss certain important terms that will be used throughout the video. So कुछ ऐसे important terms हैं that you must be aware about that I have written over here because I'll often use them in the video. So it's important that you know their meaning. So first important word that you need to be aware about is testator. Testator basically means the author of the will. Okay. The second term is testament, which is basically a person's will. And what is testamentary? Testamentary basically means relating to or of the nature of testament or will. Now the next important term is codicil. So codicil basically means an instrument made in relation to a will, explaining, altering or adding to its disposition and shall be deemed to form a part of a will. So it's a very basic term, codicil. When I'm saying, it's a way to modify your will without actually creating a new one. So sometimes when we need to make a minor change in the will, we refer to this particular term, that is codicil. So the first thing that we need to discuss in our video is what is a will. So under the Indian Succession Act 1925, a will is a legal declaration of the intention of the testator. We have already discussed, testator means the author with respect to his property which he desires to be carried into effect after his death. Now the second aspect is every person of sound mind and not a minor can make a will. So who can make a will? Every person of sound mind. That means a will obtained by force, coercion or undue influence is a void will as it takes away the free agency of the person. That अगर मैं कोई भी ऐसी will draft कर रही हूँ which is by force or which is under the undue influence of some other person, it's taking away my free agency itself. So a will made under influence of intoxication or in such state of body, mind sufficient to take away the free agency of the testator or the author will be a void will. Okay. Another important fact that you must remember, that you can very well gather from the definition or the concept itself, that will becomes enforceable only after the death of the testator. After understanding the concept of will, let's move forward. Now, we need to understand the two ways of the division of property after the death of a person. So, those scenarios hai. Firstly, if the will is there, then the property will go according to the will. Secondly, if no will is there, the property will go according to the laws of succession. Now, another important aspect or thing that you need to be aware about is relevance of a will. Why? Because when you know the relevance of a will, only then will you be able to understand that what happens in case there is no will and the person dies like that, and why the laws of succession operate or how the laws of succession operate after that. So firstly, if you have a will, dispute resolution mechanism becomes easy because there is clear disposition of one's property in a will. Secondly, by means of a will, one can appoint in writing a testamentary guardian for his infant child. Now, the third aspect is mere non-registration cannot be a reason to doubt the validity or genuineness of a will. Now, there is another important aspect, that Section 17 and 18, please be aware of the Registration Act 1908 mandates the registration of legal documents. However, there is no such compulsion that you need to register a will. However, it is preferred that you register your will to give it more validity and credibility. So this was the basic explanation part, that what is a will, what is the relevance of a will, how does the property gets divided after the death of the person. Now let's understand the procedural part of the will. Firstly, basic criteria for making a will. Now section 59 of the Indian Succession Act 1925 states that the person making the will should have testamentary capacity, sound disposing mind, knowledge of the contents of the will, and he or she should be free from undue influence, fraud, coercion, and the making of a will should be voluntary act. So now, basic criteria when you are formulating a will, you need to remember all these subpoints. That means sound mind should be there, knowledge should be there as to contents of the will, there should be no undue influence, fraud, or coercion. Very, very simple. If court finds out that you have used any of these factors, then it will not treat that particular will as a valid will. Now, moving forward, we need to make a note of conditions for making a valid will. So firstly, the testator or the author should sign or affix his mark, that is his thumb mark. Secondly, the will must be attested by 2 or more witnesses. Thirdly, the witnesses must have seen the testator sign or affix his mark to the will, or received an acknowledgement from the testator that he has signed the will. So either the witness have themselves seen the testator or the author sign the will, or they have received an acknowledgement from the testator that yes, I have signed this particular will. Now each witness shall sign the will in presence of the testator, and the witness should not be a beneficiary under the will. So these are the certain important conditions that you must follow for making a valid will. Now I have elaborated upon the registration aspect. As we have already discussed, registration of wills is not compulsory, but it is always advisable to get the will registered, as if registered and not contested after the death of the testator, probate of the will may not be necessary. So it is, though not compulsory, it is advisable that you get your will registered. Overall, why? Because the transmission of property becomes easy and higher authenticity can be attached to the particular will. Quickly moving on to the next factor, which is revocation and alteration of the will, section 62 of the Indian Succession Act 1925. A will can be altered or revoked by its maker any time, which is of course during the life of the testator. And how does the revocation or alteration takes place? By execution of a new will, by revocation of the earlier will, by registration of a new will, and this is done only in cases of the old will is registered, by destruction of the old will, lastly by inclusion of a codicil. So codicil we have already discussed. What is codicil? Codicil is nothing but the changes that you make to your will, what minor changes that you want to make to your will. So I hope you understood the clause of revocation and alteration of the will during the lifetime of the testator. What are the methods by which will can be altered? On the death of the testator, an executor of the will or the person who will receive the property of the deceased can apply for probate. The court will ask the other persons if they have any objections to the will, and if there are no such objections to the will, the court will grant probate. Now a probate, as we'll just discuss, is a copy of a will certified by the court and is a conclusive evidence that the will is genuine. Now, as already stated, is a document issued under the seal and signature of a court officer certifying that a particular will was proved with a copy of will annexed. It's basically the will is given a judicial credibility by the court. Now it's filed within 3 years from the date of death of the testator. So whoever have been appointed as executors under the will, those persons can only go to the court to apply for probate. Now जब आप कोर्ट के पास जाएंगे taking your probate request, what can court ask you? Court can tell the petitioner to establish proof of death of the testator, as well as prove that the will has been validly executed by the testator, and that it is the last will and the testament of the deceased. So these are certain factors which court may take into consideration while granting probate of a particular will, and petitioner may be often asked to prove these particular circumstances. So I hope you understood the concept of probate. Let's move forward and understand two other important components. First is letter of administration. Second is the succession certificate. So when is letter of administration granted? See, very basic. So when we have both movable and immovable property but there is no will. Secondly, when a will has been left without the appointment of an executor of the will. Thirdly, when the executor is deceased after proving the will but before the administration. Next, when the executor does not have the legal capacity. And lastly, and when the executor dies before the testator and other executor is not appointed. So basically, letters of administration or letter of administration is generally asking the court to appoint an administrator. Since we don't have a will, we don't have a authorized executor stated in the will, the person who will be in charge of all the properties, we are asking for the court that please come into the picture and appoint an administrator for this particular property and how it will be later divided. Administrator is basically a legal representative for all purposes and all the property of deceased person till its further division. So that is the concept of letter of administration. It is required to be applied in the court in the following cases. And last is your succession certificate, which is basically granted when the deceased has left only movable property. So that's it for today's video. I hope you understood the concept of will properly. What is a will? In what circumstances you will apply for a will? What is the importance of having a will? What if you don't register your will? Further understanding what is probate, letter of administration, succession certificate, what is the process, how you can alter or revoke your own will. So the basic idea of creating this particular video was to give you a background for you to further study on the concept of will. Again, thank you so much for watching. Please like, share and subscribe. And for any legal help, you can comment below. I would eventually reach out to you within 1 or 2 days. And if there's any feedback also, you can write them in the comment section down below. Any doubt again pertaining to will, you can also mention them in the comment section down below. And till then, please stay home, stay safe and keep learning.